Hello, my name is Victoria. For those of you who don't know me, I am one of the estate planning attorneys for the Kopenbarger law firm. We are very focused on making sure that you understand why estate planning is essential, but also making sure that once you know why it's essential for you, understanding that there are resources to help the person who's going to take over when you're gone and help them administer things as well. So in all of our webinars, our seminars, everything that we do, it's often pretty packed with information. And so one of the things we encourage is, again, you can use the chat function during the webinars, but you can also reach out to us after the fact. If you have not already seen us this year, by attending today, you are entitled to a free consultation. So we encourage that you take some notes and then bring those to that consultation as well. We're going to go through quite a bit, and it's in a relatively short amount of time. So again, bear with us as we go through, and please, I can't say it enough, feel free to use that chat function as we go. So for those of you who don't know Kopenbarger yet, or it's been a while since you've come to see us, you may notice that there are a few new faces. So we are a large group of attorneys that focus not only on estate planning and setting planning up for you, but we also focus on business and tax, so the more advanced questions that some of our clients have, estate litigation, which means something has had to go to court and we're still there to walk alongside you there, but we also have an estate administration team. That estate administration team to us is a vital component of what an estate planning firm should do, because not only, again, are we focused on prepping for what happens when you're gone, we want to make sure that there is someone there to carry out your wishes, to execute what you have in place, so that, again, those wishes are actually followed to the letter. But as attorneys, we could not do what we do without our incredible staff. So we have one of the largest staffs for an estate planning firm in the state of California, which allows us to address people's concerns much quicker than often is seen in the legal profession. So if you do have questions, if you have concerns and you need to reach out to us, if you aren't able to meet with an attorney as quickly as you may need, our staff is wonderful at ensuring that your questions get answered as soon as we are able. So the first section we're going to dive into is the estate planning essentials. So this is a foundation component. What I'm talking about here is what are the documents that you need? Why are they important? And if you already have put these into effect, why is it imperative that you still have them reviewed every 3 to 5 years? Anytime we're talking about estate planning, we are again talking about a comprehensive set of documents. So it is not just 1 or 2 of the documents that are applicable, but often it's 3, 4, 5, or more documents that may be talked about, because each one has a purpose and each one has a different protection that it is going to provide you, your assets, or your family. So the first document that every single person over the age of 18 needs is an Advanced Healthcare Directive. The moment you turn 18, nobody has an automatic right to make your medical decisions. That means if you're married, but you can't tell a doctor that your spouse can be in the room and make your decisions, your spouse has to have that authority in writing. Otherwise, legally, the physician isn't even allowed to communicate with your spouse. Once you turned 18, your parents lost the ability to make your decisions. And if you have children, they're unable to make yours either. The other piece, though, that's important to note with a healthcare directive is not only do you just flat need one, we encourage you to have a comprehensive healthcare directive. A lot of times with these, you can find free resources online. But anytime it's free, there's typically a reason that it is free. The quality often has been cut out for things that are provided at no cost. And so one of the things with the Kopenbarger healthcare directives is that they go beyond the surface level. Not only do we name who has the authority to advocate on your behalf, we will name who has the authority if that first person doesn't, or if the second person doesn't. So it builds in protective layers. We also go into some of the end-of-life decisions that need to be made, such as life support, which is a crucial thing to have in place because that's not a question you want your family debating over or even fighting over. You want it to be something that you have decided ahead of time. If you already have a healthcare directive, I need you to check the date of when you signed the document. If the year it was signed is pre-2004, it is no longer valid. And so you actually, while thinking you were protected still, have lost the protection. Because back in 2004, privacy laws changed to say that unless your directive has specific language complying with the privacy laws, those documents are not going to be accepted by medical professionals. So if you have not done yours since 2004 or you're not sure, come in and see us. If you have not seen us in the last few months, so basically if you have not seen us from 2025 on, there is going to be a potential concern that affects you in your healthcare directive if you have Kaiser. So Kaiser has started becoming extremely picky about specific language that they need in their healthcare directives, including with any that are prepared outside of Kaiser. They need to have specific language that says when your document goes into effect. And if that specific language is not in there, they are now rejecting any other healthcare directives. Now, if you already have a Koppenberger healthcare directive, the good news is there is a simple, easy addendum that we can add to that healthcare to ensure that compliance. If you don't have a healthcare directive yet, or we're doing a new one for you, this language will be automatically included. Now, we're focusing on Kaiser today because they are the first ones to reject healthcares without this. But Kaiser often leads the way in this matter for other hospitals. So it is worth considering, even if you don't have Kaiser, chatting with us to see, is this something you need at this point or something you will need to come back and do later? Now, the next document that you will need as soon as you turn 18 is a durable power of attorney. Now, this is the document that focuses on your finances and what happens if you can't manage your money anymore. So this could be you're temporarily unable to due to a surgery, or this could be you're permanently unable to due to dementia, Alzheimer's, or a stroke. But essentially what this document says is, if I can't pay my bills, if I can't sign a contract for assisted living, if I'm not able to manage those matters, I'm giving the authority to someone who can for me. So it is someone who can keep those financial wheels turning and allows them to use your resources to take care of you. Without this, there can be a slew of issues. One is, if they can't access your resources, does that person have their own resources to pay for their life and now take on the financial burden of whatever care you now need? The other issue, though, is if they don't have the authority to, again, sign a contract or to make those decisions, they may not be able to get the care that you now need in place on the financial side. So it is imperative that you have this document in place. Now, the caveat with this one is that banks are not accepting these if they are older than 5 years old. So if you have a power of attorney for finance that was done pre-2020, again, now is the time to come in and see us to make sure you have a current, valid, durable power of attorney, not one that you think is protecting you, but would actually be rejected. Again, if you have any questions on that, please feel free to come and talk with us. Going back quickly, we got one question about if the Kaiser healthcare directive is from 2020, do you go through them for a new one? So Kaiser should, in theory, accept their own healthcare directives, but it is not, I would definitely say there is no issue or harm in asking them if they need a new one on file. So, but if you do have one that was provided by Kaiser, I would very much hope that they accept their own documents. Newer documents that we also created in response to an issue that was brought up by a client only about a year ago is called a psychiatric healthcare directive. This is a healthcare directive that is specific to psychiatric hospital needs or facility needs. So this is not if you have a memory care concern. This is if you had something like schizophrenia or bipolar disorder. These are documents that are used if you are put into a psychiatric facility. They are now requiring a specific healthcare directive that goes beyond the Advanced Healthcare Directive that addresses questions they will specifically have for someone who has a mental health condition that needs specific treatment. So if this is something applicable to you, again, reach out, or if you know someone who this may be a concern for, please feel free to send them our way as well. Now, one of the next fundamental questions that we get is, do I need a will or do I need a trust? So That is a phenomenal question because unfortunately, especially in Hollywood, most of the time in movies and things, you hear about wills. And so most people come to us assuming that all they will need is a will. But in California, the only people that will be fully protected with a will are those who do not own real estate or people with less than $184,000. If you own a piece of property or you have more than that 184,000, unfortunately what happens when you pass away is what is called probate court has to get involved. Probate court is there to essentially say that because your estate to them was more complex than what a will can cover, they now need to step in and answer questions that they've said the will does not. So ultimately, probate gets to run, that court gets to run the show. They will get to decide ultimately who is your executor, so the person in charge of administering and settling everything. They will determine what happens if you have outstanding mortgages, car payments, any sort of loan. And ultimately, they will decide who the assets transfer to and in what way. So they, again, have a very, very large sphere of control when your estate goes into probate. Not only do they have a significant amount of control, probate is slow. So anytime something is on the court's calendar, it is not typically going to be expedient because the courts are very impacted, especially in a state like California where there are so many people. And so we see probates, especially after COVID, that can take 2, 3, 4, and even 5 years, even in simple situations. And the more complex, the longer they are. The other issue is the cost of probate. So probate costs about 5 to 7% of your gross estate. So what that ultimately means is depending on the value, let's say, of just your home, probate could end up costing your estate almost $42,000. And that's for a median home value in California. If your home is worth more than that, they're going to then obviously have a higher probate cost associated. Now, I said the gross value. So what that means is not what is your equity in the home, but what could that home be sold for? So you can imagine how much probate can deplete somebody's estate if there's a mortgage. Now you've got this probate fee. What if there was a car payment still outstanding? It eats and eats and eats away at what otherwise would have gone to your beneficiaries. Let's see. One question we just got is a manufactured home where you pay space rent considered real estate property? With any kind of manufactured home, the question we have is, do you own the land? If you do not own the land, you just have the interest in the home that's on top of it, they do still see those properties or that home itself as personal. So it is treated differently. Now, there's still steps that you want to take, but if you own the land, it doesn't matter the type of house, it's treated the same. Now, the good news is probate can absolutely be avoided, and it can be avoided typically with relatively easy steps. And the first and main one that we focus on is called a living trust. So if you already have a trust, this is going to be hopefully a refresher for you. If you don't have one, this will be a quick snapshot of what is a trust. So a trust truly is just a contract. It is something that you are creating, and you are saying who's going to be the current manager, which is most likely you. And you're ultimately also going to say who's going to manage this if you no longer can. That is known as a successor trustee. So this allows you to build in layers so that if one person can't do it, you already have the next person, the one after that. And we often recommend having even one after that if there's somebody in your life to name. That way, for one, you don't have to consistently be coming back and frankly paying an attorney to update this. But it also helps ensure that if you can't be at a place where you're managing it anymore, you're already protected. You've already put in place who's going to step in. And then ultimately, you get to name who are the beneficiaries. So when it comes to beneficiaries, this is not just a who is being named, but this can have some pretty complex terms and conversation that comes around it. You may have 3 children, but not all kids are created equal. And by that, I mean, one may be really good at managing money. One may be really poor at managing money. One may have a substance abuse issue. All beneficiaries that we talk about are looked at on an individual basis. Maybe you don't have kids or you don't just want it going to children. What about charities? What about friends or family, your alma mater? There's different beneficiary categories that we want to address to again ensure your wishes are the ones that are carried out. One of the other huge advantages to setting up a trust outside of avoiding probate and ensuring your wishes are carried out is your trust allows you to do tax planning. Now, in most cases, when we bring this up, people say our estates aren't large enough to need to worry about tax planning. We just need to focus on the simple. But unfortunately, whether we like it or not, and regardless of the number of zeros behind our bank account, taxes do affect each and every one of us. There are a ton of different taxes that we talk about. So it's not just the uber wealthy, the federal death tax that we're talking about, which currently is up at about $14 million. Most of our clients do fall under that 14 million threshold. But what about your property taxes? What about when your beneficiaries inherit that property and sell it? And capital gains taxes are now being discussed. Maybe it's income taxes even. Do you have a rental income that's affecting that? What can we do to help protect you? So tax planning comes up in a myriad of different ways, and it is a crucial thing that if you've worked with a planner who doesn't talk about any sort of tax planning, is unfortunately likely missing some big protections that could have been afforded to you. Now, I mentioned successor trustees. So typically when we're talking about trustees and who would take over if you can't, we're looking at, do you have children that you would want to? Do you have other family or friends? Do you have a person in your life that you would trust or feel comfortable asking to take over that role? But not everybody does. And so one of the things that we then work through is who can that person be? So in some cases, we talk about what are called directed trustees. This is essentially a person where you can say, hey, I've got my child and I want them to deal with the personal. I want them to clean out the house, divide up the personal items. I want them to manage that side of it. But I want what's called a directed trustee, which is somebody who can manage the financial side and be responsible for that. Now, the great thing with what's called the directed trustee is that they have separate liability from your child. So what that means is when you've named two people, if you name a non-directed trustee, known as a co-trustee, co-trustees have equal liability. That means if I'm named with a friend and my friend does something wrong, I'm now liable for that move. But with a directed trustee, if my friend had done something wrong, I can hold them accountable to the trust, but I'm now not also personally liable. So it separates me from being drug along potentially by somebody not following the terms to the letter. But some people do want that link because they want you to be accountable for each other and to be more invested in holding each other accountable. And that's where you can then look at a professional fiduciary. This is somebody who would work alongside another person, or in some cases on their own, but they would have the responsibility to make sure everything is done, not just the financial, but also the personal. So depending on if you don't have somebody who is a natural built-in successor trustee, these are options that we can discuss and potentially provide alternatives to you for. Now, I asked a few moments ago, do you need a will or do you need a trust? If you have a trust, you actually also need a will, but this is called a pour-over will. When you set up your trust, you would come in, you meet with us, we go through and explain the documents. At the end, we've had you sign and they're notarized, which means the moment you leave the room, if you've got those notarized signed documents, they are legal and valid. But that's not the last step to what happens when you set up a trust. During our signing appointments, we explain to our clients that there are certain assets that now need to be put in the name of your trust. That includes your checking accounts, savings accounts, and non-retirement brokerage accounts. So those are things that we cannot do for you. Your pieces of property are generally things we can take care of. Your house, your rental property, your land, we can do that. But your bank accounts need you to actually go to the bank and tell them you have a trust and that now those assets should be put into your trust. That's the step that ensures they do not go to court when you die. But we know things happen. Either people forget to do that, or years down the line, they open a new account and they don't remember to put the trust on, or in some cases, they're choosing not to for one reason or another. What will happen if they pass away and it's not in the trust without a pour-over will is that asset can still be subject to a full probate. But with a pour over will, we still have to go to court, but we're able to take this document into the court where it specifically says, if I left something out of my trust that should have been in there, this will says to give it back. That way the court doesn't get to dictate what happens to it or control it, and it ultimately gets given back to your trust. If you do not have a Kopenbarger trust and you are not sure if you have this document, we are happy to take a look. If you have a Kopenbarger trust, pretty much guaranteeing you have a pour over will, but we are happy to take a look again to ensure that you do have all levels of protection needed. Now, the other piece, though, of people is not just the assets and the money, but is their stuff. A lot of times stuff actually ends up being where we see the largest and most heartbreaking fights after somebody has passed away. And that is because when it comes to stuff, it's an emotion. It's not logic, typically. It's not a high dollar figure people are fighting over. It is an emotional value that is really hard to then tangibly argue about. So one of the things that we have done in our trusts is we've put a power that says, if you have a personal item that you want to designate to someone specific, that way they get the item and there's no fighting over it, you can use a letter of instruction or memorandum power where you handwrite a letter, you say what the item is, who it goes to, you sign and you date it. If it is in your handwriting, you do not need a witness or a notary because the handwriting is certifying it was you. If you have a lengthy list and you decide to type it, we strongly recommend, even with the signature and date, you at that point get it notarized or witnessed, because anybody could have typed it. You want to make sure that there's a certification that you're really the person who put this in writing. But this can cut out a lot of those fights, but it can also leave a lot of emotional value to the person who is receiving that item. So often we also hear that my kids don't want anything they've told me they don't need or want me to leave any personal thing to them. But so often we challenge that because that's likely their answer if you're sitting there in front of them. But unfortunately, when we lose a loved one, their stuff becomes the embodiment of them. That's the only stuff we can tangibly hold on to anymore. And so we very strongly encourage not only to use these letters, but if you have pictures that are their actual hard copy pictures, write on the back who's in them, what event it was taken at, if there's a date that you can put, things to capture that ultimate value that is lost if it is not put in writing. Record yourself talking about stories or things with the family. If there's items that have familial history or value to you, or again, to the family as a whole, write that down, tell somebody, make sure that that is captured. Because so often what we know is after, again, a person passes, if those things have not been documented, there's no way to replicate it. So if you do have questions on how to do that, that is something to come and talk to us about. Kopenbarger was founded because we very much believe that everyone has a legacy and that those legacies matter. And a lot of times, again, the number of zeros behind everyone's name, that fluctuates, money comes and goes. But so often the emotion is overlooked when you talk with an attorney. But the emotion, the stuff, those are the things that often can make or unfortunately break legacies after someone's gone if there's fighting that ends up happening over those things. So please, again, don't hesitate. Take the time, come and see us if you have questions on how to capture that value, how to write those letters, what do you need to do to make sure that that piece is encapsulated in your legacy. Now, there's other sorts of emotional treasures, or I'll say digital treasures. That can be in the form of your social media accounts, your email, your iCloud, all of these different accounts that are locked, hopefully, with a password. Again, if those passwords are not put somewhere that someone you trust could find and you pass away, often those accounts are then locked down and cannot be accessed. Now, some people say, well, yeah, I wouldn't want anyone to access them. But think about things like online banking. Do you want somebody to be able to keep paying those bills with an auto pay after you've passed until they can get on physically to the accounts? That could be an imperative component to keeping everything running in the immediate aftermath of your passing. Your phone, your contact list. Often we don't have address books. We don't have physical copies of where people's information is held anymore. It's all on our phones. Well, if you've passed away, assuming that there will be some sort of a funeral or a wake or celebration of life, that could be exactly the list that's needed for who to invite to that funeral. Again, if your phone is locked, no one else may have that list. What about things like your iCloud accounts or Google Photos? Those photos may be transferred onto this digital account that, again, unless someone has access either via password or on phones, you can actually set what is called a legacy contact. Unless someone has that access, those, again, assets are lost. And then a big one that we talk about now is cryptocurrency. Now, some people love cryptocurrency, some people don't understand or even like it. But for anyone who has cryptocurrency, this is an extremely valuable asset that is very easily lost after somebody passes, because cryptocurrency is not treated the same as your bank account. It is not seen right now as an asset the same as cash. It is looked at more as personal property because there's not, in most cases, a way to trace it, track it, recover it if it is lost. So it is imperative that if you have an asset in cryptocurrency form that you want transferred to somebody, that you have to put somewhere safe, but somewhere that a person could find the code or key or chain or whatever the link is to access that asset. Because again, with all of these, what we see time and time again is somebody didn't document it or put it where a person could find. They passed away, and then that value is just lost. So one of the questions, is there a way to title your bank account and add a relative so that they could take over if necessary, but anyone who sues them could not get access? So this is a very common question and a big issue, actually. Is one of the things people will ask is, can I just name my child as a co-owner of this asset? The issue with that is multifold. One is, much as you may love the person you're naming, sometimes people, when it comes to money, don't act in your best interest. And so you've now given them full access to an account. The other issue is if they are on as an owner and they are sued, now that asset can be taken to settle that lawsuit. Or if they're divorced, now that interest that they have in your asset could be taken in a divorce. The best way we recommend is to set it up in a trust where if you want your child, for example, to have access if you can't, you can either name them as a co-trustee immediately with you, where you're both on the account but under the trust, or they could be on as a successor trustee where if you can't, they're automatically the next in line. The other thing is by using that financial power of attorney, if you can't manage your account, they should be able to take that document to the bank and start paying bills out of that account pretty much immediately. So co-ownership is not what we generally recommend. Using your estate planning documents is. There's one other question that I'm not going to answer actually until the very end, but for that, the person who put that into the Q&A section, I do see it. We will get to that. So that was the fundamentals of estate planning. Now I want to get into what might have changed. What do you need to do if your circumstances have changed since you set those documents up? One of the biggest things that we see after somebody sets a document up is they assume it can now just sit there indefinitely. But your estate plan is based on your life. What that means is if you first came to us and your children were minors but are now adults, we should now talk about, are your adult children the right people to move into these different roles? Have their beneficial interests shifted at all? Have you acquired grandchildren? Do you have different charitable intent? Are you planning on moving? All of these different life changes are times that we recommend come in and see us. But one of the things we unfortunately know that happens is people assume that they can either just email us with their wishes and that will somehow hold legal effect, or that they can start writing all over their documents and initialing and dating and doing things all over the pages without ever consulting an attorney. There's numerous issues to that. For one, an email is not a viable change. If you just email us that I want my son now to be my successor trustee instead of my daughter, that's great that that's your wish, but unless it is formally done, that wish would not be carried out. For those people who we know write all over the documents without consulting an attorney about, is this an allowed change for me to do or not, you can do a number of things. One is that writing likely will not be accepted. And so again, your wish isn't actually going to be carried out. Two is it can lead to fighting. Anytime you're changing something, especially if it's a beneficiary interest, you want to do it the right way. Because the whole purpose of doing the planning is to ensure your wishes are carried out without all this other fighting that could have happened. But if you just start handwriting onto a document and it's not formally done, it invites a fight after someone is passed. And in the worst of cases, writing all over documents, unfortunately, can in some cases invalidate the entire document. So we always recommend, if you have a change, come and talk to us. In a lot of cases, yes, unfortunately, there is a change fee, but we can pretty much guarantee that the fee that would be paid will not only be cheaper than any fight that would ensue in court, but it cuts so much of that unnecessary fighting and family strife that could have happened otherwise. If you are planning to move, the good news is with estate planning, Koppenbarger can still be your attorney. But we also recommend you talk to us during that transition time because we want to help ensure that as you're closing and opening new accounts or selling and buying new homes, that those assets are being properly titled into the trust you already have. So it's imperative that if in the moving process, which I know can be very chaotic and very hectic, still make the time to come in and chat with us. A couple more questions. If somebody was married and then got divorced, or was single and then got married, and they have now a different last name than is what is identified in your documents, you have two main choices. One is you can, yes, have the documents updated to reflect that current name, but the name may change again. And so more what we recommend is ensure that that person keeps their name change documents. So at the point that they're serving for you, they have the proof that, yes, I was named as Smith here, but now I'm Hanson, or whatever it may be. So you don't have to change it as long as they have those name change forms that prove who they were and who they now are. What if you've moved to a different state? How does the trust change? Does it hold up? All of those are great questions. For those specific, I'm going to do a quick general, but for the person asking, I would very strongly recommend setting up even just a 30-minute phone call to address these more directly. But anytime you move to a new state, one of the things we do recommend is talk to an estate attorney there. It's never going to hurt to just quickly check in and see. But most of the time, estate planning rules across the country are fairly similar. We are very aware of certain states that do have specific changes that either we can address or set you up with someone who can, but the trust itself is still valid and viable. So even though it's a California attorney prepared trust, it will still hold up in any state that you are in. The other good news is if you don't necessarily like California and the rules, and that's one of the reasons you moved, the laws that will be applied will be the state that you had been residing in where you passed away. So if you were looking to avoid some of California's rules, even with a California trust, you're still going to have that effect. For those other questions, though, that the person wrote in, please, again, reach out to us so that we can answer those more directly. I mentioned a few, again, life changes that can happen. Have you gotten married since you first saw us? Or the inverse, have you gotten divorced? There are a lot of different conversations that happen in both of these circumstances. That can be name change. That can be ensuring that we are protecting if you are married and you predecease your spouse. Do you want that spouse to have full access and control over your assets? Or are you concerned about what happens if they remarry? What is the size of your estate? Do we need to do additional protection to ensure you stay under that estate tax exemption? The inverse is what if you've gotten divorced? This is a crucial time to come in and see your estate planning attorney. Because once you get a divorce, odds are, not in all cases, but in most, you don't want the person you just divorced to still have your medical power of attorney or to be the beneficiary if you are going to pass away. So it again is imperative that in these life changes and circumstances, you come in and see us. Pause for just a second. This is a great question. Can the trustee and beneficiary be the same person? Yes. So a lot of people are concerned that there is a conflict of interest if it's a trustee and beneficiary, but trustees have to follow the terms of the trust. And so in most cases, the trustee is also one or the only beneficiary that you have. Changing the trust from a joint or two-person trust to a one-person trust. That is more complicated. I would very strongly, again, recommend reaching out to us to schedule an appointment because that's very situationally dependent. All right. Your beneficiaries. So I had mentioned that not all beneficiaries are created equal, but what does that really actually mean? So when we're looking at beneficiaries, and I'm going to specifically right now focus on adult children, there can be two categories of predators you're protecting them from. One could be themselves. So in some cases, children, no matter how much you love them, may not have learned fiscal responsibility. They may not be the best at managing money. And so that could be one of the quote unquote predators that you're concerned about protecting your child from. Again, that's themselves. The other category is outside predators. What about if they're divorced? What if they're in a car accident? What happens if their business goes under or they owe taxes? How do I help protect the inheritance I'm leaving for them from being stripped away by outside predators? Both of these questions or both of these predator groups can be addressed by using what are called protective lifetime trusts. These are trusts that are set up after you have passed away, but that have to be built in while you're alive. It's essentially you're saying that when you pass, your children would still get the benefit of the money. And if you're okay with them managing it, could still manage the money, but it goes into a trust for their benefit. Either again, they can manage it, which means they can use it for themselves, they could use it for their children, they can use it for charities, but no one else can take it away from them. Or you can set up a separate manager who can use it for their benefit, but again, doesn't then allow them to take it from themselves, essentially. These are extremely crucial protections for a lot of our clients. And if you have questions on this protection, please do come and see us. This also helps ensure that after your child passes away, the money would go where you want it to go, which is typically, if you had grandchildren, going to be down to grandchildren. So what often happens if you do not have these protective plans in place is after your child dies, the money goes wherever their estate would have gone. That could be to their spouse if the spouse outlived them. But what happens if that spouse remarries? Now the inheritance you left is going to go to somebody you may not have ever known, likely didn't know. So what happens with these protective trusts is you're ensuring that the money could stay in your family line or ultimately go where you would have wanted it to. One of the questions I just got is, what is an AB trust? This is a marriage protective trust. Essentially what happens with this trust is you go from having one joint trust as a married couple into, after one of you dies, two separate trusts. A survivor can use the funds from both sides of the trust as is appropriate based on the trust terms. But if the survivor remarried, they cannot change the terms of the decedent's half. So they can't write someone into the decedent's portion or take somebody out of it. If you have more questions on that type of trust, very strongly recommend setting up a consultation. What happens if you have a special needs beneficiary? So special needs beneficiaries, what we hear constantly is, I don't want to leave my special needs beneficiary any resource because I don't want them to lose their government benefit. Instead, what I'm going to do is I'm going to leave it to somebody else who's going to be responsible for taking care of them. There are a ton of issues with this. I implore you, if you have a special needs beneficiary and this is your thinking, please do come and see us. What I can assure you, though, is if you have a special needs beneficiary and you set up what is called a special needs trust, you can leave assets and resources for the benefit of that beneficiary without causing them to lose government benefits. But this has to be done correctly. So again, if this is a situation that is applicable to you, please come and see us. You'll also notice on this screen, and I'll pause for a second if you want to take a picture or capture that QR code in the bottom right. These QR codes are there to show that we've done an additional resource video on that specific topic. So if this specific topic does strike a chord with you and you need more information, capture that QR code and it will take you to the video that dives further into this. And yes, special needs plans for adult children. Exactly. Okay. All right. Now, Kopenbarger goes well beyond what we just covered, but for the interest of this video, we're not going to go into every single one of these. But if anything on this screen strikes a chord for you as an interest, or if something on this that isn't on this screen is something you are concerned about, please come and talk to us about it. We, again, are a very comprehensive estate planning firm. And so in most cases, if it's a question that has to do with our realm, we are then able to assist you in addressing it. As I mentioned, an email isn't enough. So if you have gone through life changes and you have things that need to be updated, come in and actually see us. Please don't just send an email thinking that that's going to be the only thing that needs to happen. Because unfortunately, again, what is going to ensue once you're gone is your wishes and your intent will not be carried out. Now, I keep mentioning legacy. I, again, cannot emphasize enough. If you are concerned about how to ensure when you're gone, there is the least amount of fighting or strife or issue that can come out of, again, your passing, come in and see us now. Pre-planning is always what we are going to advocate because you can't plan once you're gone. You can only plan once you're here and plan when you have the capacity. Another issue we see is people wait too long until they are now incapacitated. And once you are incapacitated, it's frankly the same as if you had passed. There is nothing we can do with very, very limited exception to ensure that you are protected still, or that your assets or family would be protected. So if you have the capacity, I'm assuming if you're watching this video, you do not delay. Now is the time to come in and make sure that your plan is set up. Because at some point, someone else is going to be in charge of wrapping your estate up. And again, there's two options for how that person's life is going to look after you pass. One is they're going through court. The other is you set up your plan in a way that they can execute your wishes without the court having to get involved. But anytime someone passes, there are legal things that have to happen, whether or not you have a trust. If you have a trust, it is much easier to take care of and do. But in either circumstance, Kopenbarger's estate administration team is able to step in and have a consultation with the person who's now in charge. Those consultations are key because so often when someone passes, the first questions are, okay, now what? What do I have to do? What am I allowed to do? How do I get on the bank accounts? Am I going to sell the home? How do I sell the home? All of these questions are things that in our consultations with those teams, we're able to help give guidance and answers to. And in so many cases, the answer to that question is we are able to do it for you. So one of the things that is a huge benefit to, again, working with Kopenbarger is if you're in that position or your loved one is, you have a team that can actually start walking alongside you and in many cases do most of the tasks that otherwise become a burden to your loved one. One of the questions is, what if an executor is out of state? So executors or trustees that are out of state have a little bit more of a barrier at this point because they're not physically here. Typically, that barrier has to do with your stuff and cleaning out the house. However, nowadays with online banking and so much being able to be done electronically, it has gotten easier and easier and easier if somebody is out of state. So it's not prohibitive at this point. Again, there can be a small increase in not frustration, but barrier to them getting things done efficiently. But in most cases, again, it's not an insurmountable barrier. Again, when we're going through, there is a lot to be done after someone passes, and it can feel very, very overwhelming and frankly insurmountable if you do not have a professional who can walk alongside you who has done this time and time and time again. One of our roles is not only just taking care of the legal, but it's allowing your loved one to grieve. because a lot of times people can't do both at the same time. They can't fully grieve or fully do the logical legal side of it. And so we want to make sure they can do the grieving side while we take care of the legal and logical piece so that they have that time to heal and start processing. So again, it's not only making sure it's done right and just done, period, but it's giving them that time that they need after they have lost someone. So how can we help? Well, again, what we are here for is to make sure your wishes are carried out, whatever that may look like. So if you've already started this process, but you haven't seen us in the last 3 to 5 years, come in and see us to make sure everything is up to date. If you haven't worked with us yet, I hope that we will get a chance to work with you. If you already have documents that were done by a different firm, we're also able to review those for you. So if you have done work, but you're not a Kopenberger client yet, please feel free to still use those consultations. We can take a look at your existing documents and explain what needs to change, if anything. Again, if you have not seen us yet this year, you are then entitled after watching this video to have a free consultation. So please take advantage of that. If we go through that consultation and it turns out you don't need anything at this point, good news is it was free. Otherwise, what will happen is we can walk you through what needs to change, why does it need to change, and at the end of every consultation, you will understand what it would cost to make those changes. We don't work with hidden fees. We're very upfront about that. So again, if you haven't worked with us yet, please understand that you will know what it is before you're obligated for anything. So thank you again for taking the time to watch this video. I'm going to stick around for a little bit and answer any final questions that come through. We in the chat do have a survey for you. So if you can help us by answering some questions, that would be great. We want to make sure that these education events are valuable for you. And so if there was anything that we could have done better or focused on more, please do let us know. That feedback is invaluable. But thank you everybody for taking some time out of your day, and we look forward to working with you soon.